your hands together for yourselves as you take your seats. It's an honor to be here today, and we're so excited because we know that this event is an absolute success. To officially open the event, we'll be taking the welcome addresses, and to help us with the first welcome address, please put your hands together. Join me and welcome Mr. Richard Ayodele Akin today, who is a SAN and a chartered arbitrator, the vice president of BRIPAN, and the chairman of the planning committee. Please put your hands together and make welcome our vice chairman.
Thank you. A very good morning. A very good morning to all of you, those who are physically present here and those who have joined this conference online. May I start with the protocols and recognize here present this morning the president of the Business Recovery and Insolvency Practitioners Association of Nigeria, Professor Fidelis Odita, Queen's Counsel and Senior Advocate of Nigeria. Can we please give him a round of applause? Also present are members of the Executive Committee of BRIPAN in the person of the Vice President, Mr. Victor Hekwazu, Senior Advocate of Nigeria. I also recognize members of council, including the treasurer of the association, Mr. Biodun Ariibi. I would also like to recognize council members who have joined online, members of the ESCO who have joined online. I recognize in our midst Honorable Justice Ini of the Edo State High Court. You're welcome. As we go on in the proceedings, we will recognize people and do the necessary protocols. I will start my address by welcoming all of you, my lords, the President in Council, distinguished ladies and gentlemen, learned senior advocates of Nigeria here present, my lords present online and physically here. Distinguished ladies and gentlemen, on behalf of the Conference Planning Committee, I'm honored and delighted to welcome you to the 2021 Conference of the Business Recovery and Insolvency Practitioners Association of Nigeria, with the theme, Managing Insolvency During a Pandemic. This theme is very apt because, as we all know, the COVID-19 pandemic has dealt a severe blow on many businesses, leading to a rise in insolvency cases in Nigeria and all over the world. This important and prestigious conference will go to the heart of all matters relating to managing insolvency during a pandemic. The conference will also dissect the significant reforms in the Companies and Allied Matters Act 2020 and clarify all issues around regulation of the insolvency practitioner. At this conference, we will hear and meet those who are at the forefront of insolvency practice in Nigeria and around the world, as well as Alhaji Garba Abubakar, the Registrar General and Chief Executive Officer of the Corporate Affairs Commission, charged with administering the CAMA 2020 and regulating insolvency practice in Nigeria. During the 4 sessions of this conference, spanning 2 days, our highly respected and internationally renowned speakers will share, discuss, debate, and dissect new opportunities available to manage insolvency in this pandemic and put forward thought-provoking strategies that will immensely benefit all participants. This year, we have a record attendance of over 400 participants. I think BRIPAN deserves a round of applause there. The conference will afford us the opportunity to network and build a closer working relationship with our regulator, the CAC. I welcome our distinguished speakers who are attending in person and those who have joined or will be joining online. And thank you for agreeing to speak at this important conference. I welcome Mr. Scott Atkins, President of INSOL International, who is joining us online. He will deliver his goodwill message shortly. Scott, thank you very much for your support. I want to thank our gold sponsor, corporate sponsor, silver sponsors, bronze sponsors, and supporters. Without you, this conference would not have been possible. We are very grateful. I want to thank our president, Professor Fidelis Odita, SAN QC, our immediate past presidents and council members who have supported the vision of the annual conference of BRIPAN over the years. I want to especially thank the indefatigable members of the conference planning committee who have worked tirelessly to put this extraordinary conference together. Thank you all for your selfless service. On behalf of the conference planning committee, I once again welcome you all to this conference and hope that your experience in this conference will be engraved in your memory. I urge you all to continue to observe all the COVID-19 protocols we have put in place and stay safe. Have a great conference time. Thank you very much. I would now like to yield to the president of BRIPAN, Professor Fidelis Odita, SAN QC, to give his welcoming address.
There you go, sir.
Good morning, ladies and gentlemen, and welcome to this BRIPAN International Conference. May I add to the welcome which my friend and colleague, Ayo Aketunde, has just delivered. May I also stand on the existing protocols and welcome members of council, members of the executive, lawyers, bankers, friends, both those present here and those who have joined us virtually. The BRIPAN, which is the Business Recovery and Insolvency Association of Nigeria, was created on the 17th of June 1994 by very visionary leaders, many of whom are still members of council. It was formed primarily with the objective of building a body of knowledge in business recovery and insolvency among its members and other stakeholders. It was also intended to promote best practice in the business recovery and the insolvency profession. Because as some of you might know, in many jurisdictions, business recovery practitioners do not enjoy the best of reputations. Sometimes they are regarded as ambulance chasers or as undertakers acting in the shadows. But we set out in BRIPAN to correct that impression, to make sure that we observe the best market practices, and in that way to provide quality assurance to the users of insolvency professional services, to assure them that there is nothing dodgy or untoward or underhand about members of this profession, and that there are people that they can confidently entrust troubled and insolvent businesses to, with a view to assisting the rehabilitation and recovery of those businesses. So in line with our core objectives, it is not surprising that our primary goal and our primary function is training. We provide a platform for training both the very experienced insolvency practitioners who want to continue to update their knowledge, as well as the newcomers to the profession who want to acquire basic insolvency knowledge. Our primary mission is, as I said, to build that knowledge, but to use the platform of training to deliver our core objective. And every year we have a number of training programs, but the highlight is usually our 2-day international conference, which we try to host in September. And notwithstanding the challenges this year, we're glad that we're doing so. Apart from training, we also provide advisory services, often pro bono, to various organizations, the MBA, the Corporate Affairs Commission, the Securities and Exchange Commission, NDIC, and so many other organizations. As you can see from the conference brochure, our members played a key role in delivering the Companies and Allied Matters Act 2020, especially the insolvency chapters that you find in chapter 17 and 18, the corporate voluntary arrangement and the administration. So our members are very proud to have been involved in that. Today, we have in BRIPAN over 500 members drawn from lawyers, accountants, bankers, and other professionals. And the membership is growing. And we look forward to more members joining the organization and helping us to continue to build on what we regard as essential services that BRIPAN continues to provide. BRIPAN is also affiliated to international organizations. It's a corporate member of INSOL International. It has observer status with the United Nations International Trade Law Commission, the 5th Working Group, which is particularly concerned with cross-border insolvency. So on that note, I'd like to welcome all of you to this 2021 conference, and I'm sure that you're going to have a very fulfilling 2 days of interaction and exchange of knowledge and ideas and experiences about business recovery and insolvency. And as you can see from our program, over the 2 days, we're starting with our business recovery procedures under CAMA, and then we're going to look at the role of insolvency practitioners, topics which are very central to the administration of any credit-worthy insolvency regime. As you know, it's all very well for you to have legislation, but how successful that legislation is depends on the drivers of the legislation. And in the area of business recovery and insolvency, there is no one who is more important than the insolvency practitioner. And that is why today, although we begin our first topic with a new framework, we then go on to look at insolvency practitioners, how they are regulated, their qualifications, and so on. And then tomorrow, the conference will continue, and then we'll look at some other interesting issues, practical issues and challenges, and so on. Issues and challenges that insolvency practitioners face from time to time. Ladies and gentlemen, I'm sure we are in for 2 days of great learning and knowledge exchange, and I welcome you and I hope that you enjoy this conference. Thank you.
Thank you, sir. You can do better than that. Please put your hands together for our president. Thank you. All right, at this point in time, we'll take a goodwill message from the president of INSOL International in the person of Mr. Scott Atkins. Do we have the video? All right, thank you. Please, let's have that on the screens now.
It is a pleasure to be here today in my capacity as president of INSOL International to provide a welcome message as part of the International Hybrid Annual Conference of the Business Recovery and Insolvency Practitioners Association of Nigeria. BRIPAN is one of INSOL International's more than 44 member associations, and of course that's in addition to our 10,500 individual members worldwide. I commenced my presidency of INSOL International on 10 June this year, and I can tell you the time has flown by. Among my key focus areas during my presidency will be some of the following: empowering our members to understand.
Kindly play black.
It is a pleasure to be here today in my capacity as president of INSOL International to provide a welcome message as part of the International Hybrid Annual Conference of the Business Recovery and Insolvency Practitioners Association of Nigeria. BRIPAN is one of INSOL International's more than 44 member associations, and of course that's in addition to our 10,500 individual members worldwide. I commenced my presidency of INSOL International on 10 June this year, and I can tell you the time has flown by. Among my key focus areas during my presidency will be some of the following: empowering our members to understand and leverage the new technologies, tools and processes that are emerging with rapid digital transformation in the global economy. Second, pursuing new restructuring opportunities for our members that are becoming available as businesses transition to a net zero emissions future and also align their operations with other important ESG goals. Third, and very important, I think, continuing INSOL's strong leadership on insolvency and restructuring law reform and policy development. And finally, but by no means leastly, creating a more diverse, inclusive, dynamic, and impactful INSOL that responds to the needs of our members across gender, race, ethnicity, religion, sexuality, geographic location, and discipline. I can certainly say that INSOL's relationship with BRIPAN is one that we value immensely, and Nigeria and the broader African region is a key geographical focus point for INSOL in coming years. Indeed, INSOL has, over the last 10 years, operated an African roundtable on insolvency reform. Over this time, ART has contributed to significant insolvency law reform discussions and has worked to build closer partnerships among judges, practitioners, regulatory and policy bodies, and academia within the African region, including, of course, in Nigeria. During my time as president of INSOL International, we intend to build on and enhance the work of ART and make continued restructuring and insolvency law reform, policy development, and capacity building a key priority in Africa, as well as in other emerging economies and well-established economies. I know that one of the key challenges for Nigeria at present, as with other nations across the globe, is how to effectively transition from COVID-19 emergency fiscal support measures and interim insolvency relief towards a more sustainable, enduring law reform system and the implementation of measures to support that. And one area of significant priority is the simplification of insolvency processes and the adoption of more flexible restructuring alternatives. This is a particular issue for micro and small to medium-sized enterprises, which function as the lifeblood of any local or regional economy. In Nigeria, these more flexible restructuring options for MSMEs can, I believe, function as an important component of the country's future economic and financial stability. Indeed, there's a very strong synergy between an effective and best practice insolvency system with a priority on giving distressed but viable MSMEs access to lower cost, quick and simple restructuring options, and the reforms introduced in Nigeria under the Consolidated Companies and Allied Matters Act, which I believe came into effect in August 2020. The CAMA prioritises reduced red tape for MSMEs and a less complex regulatory environment intended to overcome the difficulty that MSMEs have encountered for 3 decades in doing business and leveraging international investment. This is certainly a very encouraging step. Of course, the CAMA also introduced entirely new insolvency processes for Nigeria, which before the CAMA were limited to just receivership and liquidation. The new insolvency processes now include administration and voluntary arrangements, such as a debtor in possession model. These alternatives will undoubtedly assist in creating a stronger rescue and restructure culture in Nigeria, which is very much something that INSOL seeks to support across the globe. Going forward, the adoption of further MSME-specific restructuring processes will be, in my view, a very beneficial option for Nigeria to pursue. With that, can I again sincerely thank you for the opportunity to be with you as part of your annual conference. I wish you all the very best for your proceedings over the next 2 days, and I certainly look forward to hearing more about your program of events. Thank you very much from all at INSOL.
Thank you. All right, ladies and gentlemen, we go straight into the first session for the day. I'm so excited because, you know, when an unlearned fellow like myself sits in the midst of such learned fellows, I know there's so much to learn, and I'm really excited. I'll be taking notes. All right, the theme for this first session is New Framework for Business Rescue in Nigeria, and the coordinator for this is Mrs. Temitope Aribisala. Temitope, you're on standby. Thank you. Join me and welcome the moderator for this session in the person of Professor Fidelis Odita, QCSAN, Principal Partner, Fidelis Odita and Company. Please put your hands together for him. You're welcome, sir. So at this point in time, we'll be having our speakers take on the topics. Thank you, sir.
Once again, good morning, ladies and gentlemen. We are now starting the first program for, I beg your pardon, the first session for today, the new framework for business rescue in Nigeria. Chairman of our conference organizing committee, Mr. Ayo Akechinde, has already introduced this topic briefly for us when he spoke about the new provisions for business rescue under the Companies and Allied Matters Act 2020. To help us discuss the issues arising under the new framework, I've got 4 speakers, very learned speakers. The first person that I will call to talk about administrations and CVAs, the UK experience, is Mrs. Tina Lockwood, who is a partner in the Restructuring and Special Situations team of Simmons & Simmons LLP, which is an international law firm based principally in the UK. I'm sure that Tina Lockwood is online, and if she's there, I invite you to make your presentation. But just before you do that, and by way of organization, I would invite each speaker to speak for about 20 to 25 minutes. After that, we will have a question and answer session, which we could do depending on how the questions come in. We could do them at the end of each topic, or we could take them globally at the end of the session. But we'll see how we go. So, Tina Lockwood. Is she online? Hello, Tina. Can you hear us?
Can you hear me?
Yes, we can now.
Wonderful. Invited to speak at your conference, and I am amazed by the technology that allows me to sit here in my spare room in my house in London to share my experiences of the UK use of the administration and company voluntary arrangement processes. I can't see my slides. Somebody was going to share my slides for me so that I could talk to them. I've prepared a short slide deck that I would like to just present to you, and I will talk to those slides, I will talk around those slides, and I will invite you to make questions on my topic.
want to deploy some of the mechanics that a CVA can offer to fix those problems. So a CVA is a compromise. It's like it's basically the will of the majority being forced onto the dissenting minority. It is a statutory form of contract that is imposed on a group of creditors. It is basically an arrangement that is between the company and between some or all of its creditors. There is no need for a separate creditor class. So all unsecured creditors vote together. The only exception is that a CVA cannot be used to bind secured or preferential creditors under English law without their consent. And that in practice has made CVAs sometimes a little bit unpopular because you don't have that flexibility or ability to be able to bind all of your creditor base. So only schemes of arrangement, and more recently, restructuring plans allow for a company to compromise the claims of its entire creditor base. And so how has this problem played out? So it isn't unusual in practice in more complex debt arrangements to have what we call interlocking CVAs and schemes of arrangement, which are put in place simultaneously to address the claims of all the creditor classes. So it's a statutory process. It is set out in some short sections in our legislation. It's deliberately light on detail, which means that actually it becomes quite a flexible tool in terms of what you can use it to do. The proposal can be made by the directors of the company, and it can also be made by an administrator or a liquidator that is already in one of those processes. Crucially, it can't be proposed by the creditors themselves. So in terms of the process, the company will work on putting together its compromise agreement, and that process is overseen by the nominee. So the nominee is an officer of the court, usually in practice an insolvency practitioner, an accountant, that will work with the company to review the proposal and to oversee the creditors' meetings to get approval of it. That proposal is then made to a meeting of the creditors, and in certain circumstances where the proposal's by the directors, to the meetings of the shareholder as well. Those meetings, both of those meetings, have to approve the proposal for it to become binding. And as I said at the beginning, this is a compromise. It's the majority imposing their view on the minority. So the approval thresholds are 75% by value of creditors that attend the meeting, either in person or by proxy. And of those, at least 50% by value must be unconnected creditors. And what do we mean by that? So the connected person rule is considered on a case-by-case basis. So it generally allows groups of companies. It means directors, shadow directors, their families, they will all be seen as connected persons. Also extends to associates. And the fundamental principle behind that is to protect the minority creditors' rights. So because this is a cram process, you're cramming that minority 25% who vote against the proposal. You don't want to have a situation where connected parties could come together to form a requisite majority that would essentially cram down that minority interest. If you would please move to the next slide. So once the proposal has been approved by the meetings of creditors and shareholders, it then has to be reported to the court, and then it's implemented under the supervision of a licensed insolvency practitioner who is known as the supervisor. So it's normally the nominee that then takes on the role of the supervisor. Once it's approved, it binds all the unsecured creditors that were entitled to notice of that meeting, whether or not they attended. So it is quite powerful. It can be challenged. So there are bespoke challenge rights. So a creditor entitled to notice of the CVA proposal, who believes that that proposal has unfairly prejudiced their interests as a creditor, or where there has been a material irregularity in relation to the meetings to consider that proposal, they could challenge it on those grounds. So going back to the point I made about connected parties, if there was an issue around potential connection, that could be seen and could be challenged as a material irregularity under English law. The time for bringing those challenges is 28 days from the outcomes of the meetings, from when the meetings are reported to the court, or if the creditor wasn't given notice, 28 days from them becoming aware of the meetings being held. So once, just very quickly at the end of the process, and then I'll talk a little bit about it in practice, it can the CVA ends when there has been a successful implementation of that approved arrangement or the compromise. And then if the creditor cannot comply with it, then the CVA document itself should set out the exit routes that would then follow. And normally it would be that the CVA supervisor petitions for the company's liquidation. Next slide, please. So uses, it's very flexible. It's been tailored to deal with a lot of different situations. A key benefit is that it can be quite quick to implement. So from start to finish, you could get your CVA in place within a matter of weeks. And that's really quite critical sometimes. It also makes it cheaper than potentially other statutory compromise mechanisms, such as scheme of arrangement or a plan of reorganisation, restructuring plan. There is also limited court involvement, and this also feeds into the cost factor. You're not having to instruct counsel to make court appearances and attend court hearings. It's a good option for companies that are facing legacy costs. And where we see it used a lot within the English market is in respect of property-related liabilities. I will talk more about that and give it some context very shortly. It's also, as a technical point, a very good way of delivering a distribution within an administration process. So an administrator doesn't have power to make distributions to unsecured creditors without obtaining permission of the court. So this is a way, because an administrator could propose a CVA, they could use that tool to actually compromise creditor claims and agree to pay creditors on a basis which isn't a pari passu basis. And that would remove litigation risk for the administrator, for the estate, and it's cheaper than the administrator putting the company into a subsequent liquidation to make that distribution to the unsecured creditors. And I've been involved in a number of cases where that's happened. And in fact, one of my first cases when I moved to London was dealing with a legacy Enron CVA, where Enron was in administration, but the administrator had put in place a CVA to effectively do just this. CVAs could also be used in the context of what we might call a trading CVA. So the company continues to trade and it's using its trading cash realizations to repay its debts through those profits. And quite crucially, the management remains in control, which is very different if you contrast it to an administration process where the administrator would step in. Crucially, though, another key difference, I think, between this and administration is that there are no powers of investigation into conduct or no ability to bring any antecedent transaction type claims. And that actually might be a relevant consideration for directors. Next slide, please. So it's also been used in the context of effecting debt for equity swaps. And so under English law, where we've seen quite substantial pension liabilities, where you've got a pension deficit that needs to be dealt with, then it has been used quite effectively to put in place an arrangement where the pension fund takes an equity stake in the employer entity. It can be used for preparing a company for a share sale, so dealing with compromising liabilities and restoring solvency prior to a sale of shares by the parent company. But as I mentioned, very popular in the retail sector, and I think focusing on the theme of this conference and how you might use some of these tools to deal with some of the issues that the pandemic has thrown out, it's actually very worth noting that where we have seen in the UK a retail sector that has been very heavily hit by the effects of the pandemic, by the lockdowns, by shops just having to close their doors and not have any customers for months and months and months. That has meant they have been unable to service their leasehold liabilities. And so we've seen some CVAs come through that have attempted to address those types of issues. And one in particular that I've noted on this slide is a very big case. It was quite a fundamental case that was brought before the English courts in the early part of this year. And that related to a clothes retailer, a national retailer called New Look. Over 400 stores, very significant rental liabilities that were built up because of the coronavirus pandemic. And the company used a CVA to do several things and to do several quite far-reaching things in terms of its liabilities to those landlords. So it forward-looking used its CVA to amend the basis on which it was paying its rent, and it introduced a turnover rent and imposed that on its landlords through the CVA structure. So basically landlords that were otherwise being paid according with the contract terms of the lease were suddenly, as a result of the CVA, now having to face tenants paying a percentage of their turnover in respect of their rent. So quite a fundamental change. It also put in place a rent concession to enable a lot of the stores to build up and deal with their cash flow cash flow issues that they had been facing. The landlords, unsurprisingly, were not very happy with this, and they threw everything at challenging this CVA. They found how their claims had been calculated for the purposes of voting. But the courts in England were very pragmatic in their response to those challenges, and actually those challenges were all unsuccessful. The courts primarily took the view that actually the alternative for the New Look retailer, in the absence of this CVA going ahead, would have been insolvency. And that would have meant that those landlords would have just had emptied, shut down, boarded up stores with no prospect of a rental income going forward. The courts also took into view that the terms of that CVA actually enabled the landlords to exercise a break and to walk away if they thought they would get a better offer than that was being put through the CVA. And so the court said effectively, if you don't like it, you don't have to accept it. You can walk away and get an alternative tenant. And that in our mind gives you sufficient protection from what is being proposed. And I think really just to reflect on that, I think it's quite important because it shows how this sharing of pain is very much a recognised concept as we, as a nation, as a world, try to pick ourselves up from the economic fallout from this pandemic. And that's CVAs. If you could please move on to the next slide, I'll talk very quickly about administration. You just need to go through. Yep, there we go. Thank you. So administration, what is administration? So it is a rescue process. It's a route that allows for a reorganization of a company and the realization of its assets under the protection of a statutory moratorium, which is quite an important fundamental feature of what an administration offers to a distressed corporate entity. The administrator can be appointed under English law by several routes. So there's a court order application that's based on an application. So you make your application, you put together all your evidence, you file it, and you get a court hearing. And that application can be made by a director or one or more of the company's creditors. It can also be made out of court by the holder of a qualifying floating charge security, or it can be made out of court by the company or its directors. Which appointment route you would choose generally, I think, comes down to entitlement and also timing. So if you're going through an in-court appointment route, that takes longer, just by definition of the process that's involved. You also have some inherent court risk around whether the judge will make the order that you are seeking. If it's out of court, if there's no qualifying charge holder who isn't otherwise entitled to receive notice, then actually it could be very quick. It is a matter of just filing some forms at court. Soon as they are stamped, the administrator is appointed. So it can be very, very swift in an emergency situation to get in. The administrator, he or she is appointed as an officer of the court, and they have very, very far-reaching powers to essentially manage the business, the affairs, and the property of the company to pursue the purpose of the administration. And as they are doing that, they are acting as agent of the company, but with the interests of all creditors in mind. And that's an important distinction from receivership, which I understand under Nigerian law, you've been very commonly dealing with. The receiver is acting very much for one creditor. The administrator is acting for all the creditors. Important distinction. If you could please move on to the next slide. So there is a statutory purpose that has to be identified before the administrator is appointed. Otherwise, the administrator cannot take that appointment, and he has to swear that he believes, acting reasonably, that that statutory purpose is capable of being achieved. And those objectives are essentially in an order of priority: whether the company can be rescued as a going concern, whether it can achieve a better result for the company's creditors as a whole, or if neither of those is possible, whether it is possible to realize property to make a distribution to the secured or preferential creditors. So the moratorium is a really important function. And so once the company is in administration, or if a notice of intention to appoint an administrator needs to be filed, then the moratorium becomes effective. And that basically stops commencement of insolvency proceedings or other legal processes in respect of the company, mindful of whether it's in the best interest of the creditors as a whole. An administrator acts on behalf of the company's creditors as a whole and may do anything that is necessary to manage the business and affairs of that company to which he is appointed. And that also includes the ability to apply to court to seek permission to sell charged property. So the success of the administration quite often depends on the value of the assets that are available to the company, and also the ability of the administrator to deal with those assets freely and to achieve the best outcome possible for those creditors. If the administrator wishes to dispose of that otherwise charged property, then he can apply to court to do it. But conversely, a creditor who may wish to enforce its security would risk jeopardizing that moratorium and that protection. So there is a little bit of a balancing act that has to be done. And of course, there are two types of security interests that might be at play. And there may be floating charge security in place, in which case those assets are actually free to be disposed of by the administrator as if they were not subject to that charge. And that means that in practice, the administrator doesn't get held ransom to those floating charge holders, because quite often those floating charge assets like stock, they are needed to produce the cash income to fund that administration process as it seeks to achieve the purpose. Where you have fixed charge security, the administrator can't dispose of those assets without applying to the court for consent or permission or the consent even of that charge holder. If the creditor thinks that the administrator is using their charged assets without their consent, then they can challenge the administrator's conduct on the basis that it is unfairly prejudicial to their secured rights. But in any case, if an asset subject to fixed charge security is disposed of by the administrator, then the holder of that fixed charge security may be repaid out of those disposal proceeds. If you could move on to the next slide, thank you. So administrators' powers, very broad. They are set out into a schedule to our Insolvency Act, and they are taking over the management and control of the company. They can remove and appoint directors, they can borrow money, they can dispose of assets. They can also conduct investigations. So they can deal with directors' conduct, they can examine directors, and the directors have an obligation to cooperate. I was involved in a matter where there was a very big fraud, and the quickest way to take control of that situation was to appoint an administrator and use the investigatory powers to find out what had gone on, where all the assets had gone to. The administration, unless it's extended, lasts 12 months. It's a very swift process. One point that's worth noting, again, in the eye of looking at how we come back from the COVID pandemic and how you could flexibly use these tools, is what we have used and refer to as a light touch administration. So this is using an administration, but having the benefit of an agreed protocol between the administrators and the management team, where the administrators agree that they'll be in place, they'll be in situ, the moratorium crucially will come into play to protect the entity from any attacks from creditors. But the management team remain in control, they continue to trade and to perform what the company is doing, but all subject to the oversight by the administrator. The exit routes to administration. So if the purpose is achieved, the company can emerge and continue trading, and it's business as usual with its restructured business. However, it could be that the business and assets are sold during the administration, and that leaves just a shell, which therefore just gets dealt with through a dissolution process. Or if there's been a sale of business and assets and it hasn't been possible to make a distribution to creditors, then the company could move into liquidation and could make its distribution that way. Next slide, please. Just a final note on pre-package administrations, because again, this is a very powerful tool, and it's also a controversial tool, but it's something that is very relevant again as to how you use these tools effectively to deal with difficult situations as we emerge from the pandemic. So a pre-pack sale is basically a sale of all or part of an insolvent company's business that is arranged and agreed and entered into. Essentially, all the contracts are prepared. And then as soon as the administrators are appointed, or very shortly following that appointment, that sale concludes and the new owners take ownership and the sole business moves forward, leaving behind everything else for the administrators to deal with. Pre-packs have been developed over time by insolvency practitioners. So this is not something that is provided for in statute. It is a way that the administration technology has been adapted and has evolved to deal with situations and to help businesses be rescued by maximizing realizations. The key advantages to a pre-pack are that it can avoid negative publicity. So all that publicity you see around distressed companies as to whether they're going to fail and when are they going to fail, which is value destructive, can be avoided because all of the negotiating around the sale and getting everything locked up and agreed can happen in the background very quietly, essentially, without that media glare and spotlight. It also can prevent job losses and keep suppliers and customers intact. So essentially, you can deal with a pre-pack where the appointment could happen very early in the morning, and then when everyone turns up to work, they are working for a new employer who now owns the business, but there hasn't been that disruption. And it, quite crucially, all of this serves to preserve funds to pay creditors. Next slide, please. But they are controversial. They're controversial because it could be seen that a pre-pack is asset stripping. So it is allowing directors to sell the valuable assets without a visible marketing process with little or no warning to the company's creditors. and they're leaving behind the liabilities owed to those ordinary creditors and to the pension schemes potentially, where there's been a sale perhaps to a new company that has controlled or has very strong links to the directors or the management team of the old insolvent company. So what's happened under our law to try and mitigate for those risks? So our government's been very closely watching all of this and has done a number of things over the years to try and protect creditors from these perceived risks. So we have basically a statement of insolvency practice, a SIP 16, which sets out a code of conduct to be followed when doing a pre-pack sale. There is also an introduction of a pre-pack pool. That is a pool of individuals that can be consulted around the pre-pack and can give an opinion as to whether they think that is a fair use of that process. And finally, more recently, we have seen an introduction of an evaluator. So if you could please just move on. I've summarized in SIP 16 the next two slides, which hopefully you have access to in your packs. But I talk about SIP 16 and the following slide, if you could please move on again, because I'm running out of time. If you just flick forward to the next slide, there is an evaluator. So I've summarized this new evaluator process, which from April this year has come into play, again, to still try and protect creditors and to introduce some more transparency of the pre-pack process. So you're using an evaluator now that is appointed as an independent body and has a requisite knowledge and experience to provide a report on the proposed pre-pack. And that report is sent out to all creditors and is filed at Companies House, so it becomes a public record document. So that's introducing transparency of process, and it's hoped that through that, more confidence will be regained in the use of the pre-pack process, because it can be a very effective way of preserving value for creditors. And I think we will probably see within our English market a continued use of this process as companies restructure and move forward and emerge from this global pandemic. Thank you very much, everybody. That is the end of my presentation, but I would invite questions, I think, at the end when we have our panel discussion. Thank you.
Thank you very much, Tina, for very detailed and informative presentation. We'll take questions at the end of the session. The next speaker or presenter is Mr. Jide Ogundikwe, who is a co-founder and at the moment senior partner in Shofunde Osakwe and Bulgarian. I will invite Jide to speak on informal rescue procedures.
Good morning, everyone. Thank you, Fidelis. In introducing me and in your reference to my firm, you forgot to mention my name in the name of the firm, but I forgive you. I'd like to thank the organizers of this conference, BRIPAN, for inviting me to speak at this conference, notwithstanding the fact that for reasons which I will not explain now, I am still not a member of BRIPAN, but all the same, I thank you for inviting me. When I was approached and asked to be part of this, I was given a number of topics from which to choose. And being the lazy sort of person that I am, I opted for the subject that I'm going to talk to you about or discuss with you, informal corporate rescue. Because looking at all the topics that were offered to me, this one looked like the easiest one and the one that needed the least amount of work. So you are here listening to me speak about informal corporate rescue. Now, anyone who's looked at the, thank you for putting up my slide. Yes, with regard to this, I was also asked, please let us have your slides. As I told you earlier, I'm someone who likes to do as little as possible. So I said, well, I'm not using any slides. And I was persuaded to have one slide that lists out the talking points, the points that I'm going to speak to. And I just wanted to say something about slides. Over the last 3 or 4 years, or well, probably 4 or 5 years now, because you can take 2 years out for COVID. Whenever I have these presentations to make and people ask me, do you have slides? I've tended to be very flippant and say, oh, slides are so 20th century. And that I'm just going to speak. It's another piece of evidence of how lazy I am and how I prefer not to do any work. Anyhow, if anyone looks at our Companies and Allied Matters Act of 2020, it will be apparent that the term informal corporate rescue appears nowhere. In fact, the word rescue appears only once in the entire 600+ pages of the legislation. And of course, this is not unexpected, given that the nature of the procedure is encompassed in the first word of the term, which is informal. So the question is, what is informal corporate rescue? In Nigeria, I make this point that informal corporate rescue is not calling on a friendly police or EFCC officer to help sort out a corporate debtor, or arranging to send some thugs to the office of a chief executive to persuade that debts be paid. Workouts and debt restructurings, and it's seen a steady growth around the world in recent times. Now, when I was preparing for this, I was reminded of my first experience of an informal corporate rescue. I was a young practitioner. I was working in Chief Rotimi Williams' chambers. For those of you who are Nigerians, you will know who Chief Rotimi Williams was. The fact that I worked for him for 8 years, notwithstanding, I still think he's the greatest lawyer that Nigeria has ever produced. Anyhow, he sent me a file from a client that was a company where he was also the chairman. And he said that that the company had a particular debtor that had ignored all efforts to secure payment of what was owed, and that he'd like me to work on it and find some method of getting the debtor to pay. So I looked at it and I decided, in those days, the Federal High Court I decided that, okay, let's file a winding up petition. And because in my view, the failure of the company to respond to the client indicated serious financial instability. So we served the petition, and shortly thereafter, the company dispatched someone to come and meet me to discuss the matter. When the guy came in, I was totally unimpressed with him rather, because he didn't appear to be a very senior member of the company's management. And as a very self-important young lawyer, I was upset. I felt the company wasn't taking the client or me seriously. And then secondly, to reinforce this first impression that I had, he came up with what I considered to be an extremely paltry offer of instrumental payments that would have taken ages to pay the debt. So I reported to my boss, and he said, okay, Jide, don't worry, I'll follow up the matter with the chairman of the company, who he happened to know very well, as was and remains the case in many instances in Nigeria today. I subsequently learned that the matter had been resolved, as the only thing I heard about the actual proceedings in court was that I should discontinue the petition. Now, it's relevant to say that the distressed company later grew to become a significant Nigerian player in the oil prospecting and producing sector. And the informal discussions between Chief Williams and the chairman of the distressed company saw the company not only survive the attempt by me to wind it up, but it went on to thrive. I won't name the company because it's still doing great business. So there was my very first introduction to an informal corporate rescue. The exact details of it, other than the fact that the company was paying, making payments in installments, I can't share with you because nobody bothered to share it with me. Now, these procedures, they obviously contrast with the formal processes, such as court-led or supervised procedures that seek the rescue of a business by process. Tina has already given you examples from the UK, and another example would be Chapter 11 bankruptcy in the United States. Now, these procedures typically involve debt reductions, the granting of extensions of time within which to pay liabilities and similar things. The main effort of these procedures would be negotiations with creditors, and these are primarily bankers. In addition, you'd have suppliers, vendors, and the tax authorities. And these procedures typically make for a much less expensive process, a point that Tina made mention of earlier. And they are certainly a preferable alternative to winding up proceedings. For the distressed business, it's often a viable way of getting back to financial health. And for creditors, it could present an opportunity to get a better return in the event that the procedure succeeds in restructuring the business and keeps it as a going concern. Out-of-court debt restructuring processes have an extremely long history, and they can be traced back to sovereign debt defaults. These arguably go all the way back to the medieval period and have continued throughout the 20th century, with probably a peak in the 19th century. More recently, the procedure has been attributed to guidelines formulated by the Bank of England, and which later came to be known as the London approach. This London approach can be traced back to the 1970s, when the United Kingdom experienced, what can we call it, a prolonged period of unrest. I was in England at the time. There was a 3-day week, lights going out, miners on strike, and all manner of things going on. And during that period, the Bank of England came to the realization that the formal procedure under then existing insolvency law simply wasn't suited to securing constructive corporate survival. And what was needed was an intermediary that could organize discussions between creditors and debtors, and at the same time, apply a set of guiding principles to guide the implementation of a viable recovery package. Initially, the intermediary role was taken on by the Bank of England itself, leveraging on its position as a regulator, the regulator of the banks, from which position it could lead commercial banks towards the recovery of the debtor business. The Bank of England was able to engage in this activity because the description of its functions under its statute was sufficiently fluid, and it was concluded, and it turned out to be the case, that there were no regulatory obstructions to its taking this intermediary role. Obviously, as the Bank of England, it enjoyed significant trust, both from the businesses that were distressed, and from the banks to which monies were owed. And this was important because the assistance the bank provided didn't require the bank to be paid. As a result, the bank could organize meetings of creditor banks, appoint a lead bank from amongst the creditor banks, facilitate discussions, and generally help the parties to work towards some sort of consensus that would usually consist of things like interest holidays, additional financing, management changes, fresh investments, debt equity swaps, and similar things. Over time, the role of the bank changed from that of an active participant as an intermediary to more of an honest broker in negotiations between the parties and in the formation of restructuring packages. By the 1990s, the bank decided to restrict itself to being a passive participant and to play a minimal role in the review and the framing of rescue packages. And to assist it in doing this and to assist the practitioners in understanding how to approach this London approach, guidelines were drawn up, and they were called the London approach because it was really a very, very informal process, and calling these things guidelines would possibly have indicated a great deal more structure than actually existed. And I've tried to summarize some of the features of the London approach, and I've come up with seven points, which I'll quickly run through now. The first is that creditors have to be ready to compromise to the extent that they don't require immediate payments by the distressed business, and they need to demonstrate a commitment towards allowing workouts to be developed. Second, creditors were required to commission an independent group of experts, like the evaluator that Tina referenced earlier, to review the finances of the distressed business and to advise on appropriate steps to be taken. The creditors also had to agree to a temporary standstill so that the business remained able to operate during the review. Fourth, a lead creditor had to be selected. Fifth, it wasn't mandatory that there had to be a restructuring at the end of the exercise, so that you would make an effort, and at the end of the exercise, the creditors remained at liberty to decide whichever way they considered to be best after the conclusion of the review. They could decide at the end of the exercise that this isn't going to work, and then formal insolvency proceed could be taken up. Sixth, in the event that additional money was needed to be put into the business, some agreement had to be reached that such money would have some sort of priority during the recovery or the payment process. And the seventh principle that I managed to distill is the pari passu principle had to be recognized with regard to the collection of the proceeds, the sharing of the burden of losses, and the seniority of claims had to be recognized. Now, this approach enjoyed a fair degree of success, and in 1998, the role that was played by the Bank of England was passed on to the Financial Services Authority under the 1998 Bank of England Act. And because you now have the FSA involved, so perhaps people weren't so interested. And the UK developed other things to address corporate insolvency. Other issues affected the use of the London approach, and these included the practice of engaging independent legal advice. As we all know, we lawyers, we have a tendency to be a little expensive. So that was one of the things that hampered the use of the London approach. And another one is the diversification of the creditor base, because it turned up, I mean, as time moved on, the creditor base came to include not just bankers and lenders, but you had bondholders, secondary market investors, And then you had all manner of novel financing structures that had to be addressed. And then there was globalization, which came in as well. But in spite of this, the London approach has formed the basis of models that have been adopted in a number of jurisdictions around the world. The ones that immediately came to mind, Thailand, which has a Bangkok approach, Indonesia, South Korea, Argentina, India, and South Africa have all adopted something that was influenced by the London approach. So that's just a quick description of what informal rescue procedures comprise of. Now, why use them? These things can go on. Nobody needs to know. The point was made by Tina previously with regard to pre-packs. No one needs to know what's going on. The banks will get together, the creditors will get together, they'll talk to the company, they'll discuss the issues and try to find a resolution without risking the business, without risking the employees, etc. Risks. The most significant risk that occurred to me when I was considering this is the risk to directors of continuing to trade when essentially business is insolvent. So there are fraud issues that need to be considered on the part of the directors and management of the companies, of the businesses. And how can this be applied to Nigeria? That's a difficult question. One of my current bugbears is what I consider to be the inordinate advantages that are conferred on a certain agency when it comes to insolvency matters. I think that it really isn't fair to give such an agency, I understand why they do it, such an advantage over other creditors. We understand, yes, banks are the major creditors in these situations. But in Nigeria, we have this agency that has so much power, really. I mean, it's truly amazing the power that they have. And they essentially trample on other creditors and leave them in the dust. The other concerns that I have relate to the manner in which the financial sector is regulated. I have concerns about the equity with which the regulators approach certain things. But there are certainly lessons that can be learned. There are things that can be taken from the procedures that exist around the world. And it's definitely something that one needs to look at. So I believe I've spent about 18 minutes talking. I was going to do 20. I've come in under my time, and I thank you for your attention.
Thank you very much, Jide Ogundikpe, for that presentation. Our next presenter is Mr. Oyedele Oluwatosin, who is the Director of Strategy and Transactions at Ernst & Young. He is going to speak to us about the practical issues involved in preparing successful rescue and restructuring plans.
Many thanks for the introduction. Can you please enable me to share my presentation, please? Good morning, everyone. Just to confirm that everyone can hear me clearly.
Yes, we can hear you.
Fantastic. Also confirming that you can see the presentation slide.
Yes, we can see your slides.
All right. Thank you once again. And I'm actually quite humbled to be called upon to make a presentation to everyone present. And as introduced, my name is Tosin Oyedele. I work as a director within the Strategy and Transactions Unit at EY West Africa. This morning, I've been asked to make a presentation on the practical issues in preparing a successful rescue and restructuring plan. And one of the first things that came to mind is how really it is difficult putting together a plan, especially for a business that is stressed and almost going towards insolvency or really in a distress situation. And which is why you would see the picture in front of you is like really pushing a rock down the hill and ensuring that it goes down the slope in a very orderly and planned manner. But as difficult as it might be, I think one of the things that I would say is that once you can get the rock at the right position and you properly get the slope and tilt it, things move on smoothly with proper guidance. Part of the things I'll be talking about today is the what, and really what exactly do we refer to, or what do we talk about when we talk about business restructuring. Again, I wanted to share from a strategic point of view, what exactly, how do you view restructuring strategically? Also, I would be highlighting some triggers that may necessitate a restructuring or rescue plan, and probably discuss that on an high-level basis. What I want to focus on today is talk about the approach, a three-stage approach to restructuring, and also what practical issues one is to consider when putting up that restructuring plan. I will conclude my presentation by highlighting some key restructuring levers, and aligned to that would be considerations for restructuring practitioners, advisors, executive and management of company. Just going straight into the what, when we refer to business restructuring, it might signify, in most cases, people's mind that are tilted towards financial restructuring. A lot of the conversations that have been had today has been about businesses going into insolvency, inability to make debt payments and things like that. But when we really do look at restructuring, it could be financial and it also could be operational, right? And one of the critical things about restructuring process or restructuring itself is what exactly is the end point. Is it that to retain value or to grow value for the company and ultimately its stakeholders? Activities that you would hear about in a restructuring process would include debt refinancing, cash flow monitoring and improvement, sometimes staff rationalization, business model realignment and things like that. But there was something Richard Branson said, which is key to any restructuring process. One is that you never should take your eyes off the cash flow, because that is the lifeblood of the business. Most importantly, even for a business in a crisis situation, expecting to either be rescued or restructured. From a strategic point of view, one of the key things I would want us to leave this place with is to not see restructuring as mainly a process that is initiated either in a crisis situation or in a stress situation in an organization. Restructuring really could actually be a tool a business uses to reposition itself for growth. The main questions you then want to ask yourself is, when exactly, as a practitioner, when looking at an organization, or as an executive or management, when exactly should you really be considering a restructuring plan? And thinking about it, the things that came to mind based on my experience, a couple of points which I've highlighted up there. One is, when you look at your business strategy or your business model, and you ask yourself questions like, how sustainable or how successful do you think your business model is? And your answer is to the negative, then you probably should be considering a restructuring plan. Also, when you look at your capital structure and you realize that it is not optimally structured and you are either over leveraged or geared, as the case may be, then you probably need to be considering some financial restructuring. Some other things you also want to look at is, how are we positioned as a business within the market we operate in? How competitive are we? And is there an opportunity in the market for us to actually pull certain levels to then gain some additional competitive advantage? And you could do that by either restructuring from a geographical perspective, or from a product perspective, and what have you. Also, from a profitability perspective, you want to really ask yourself, are there product lines or service lines within your business that are pulling down the group's profitability? And then questions around divestment or carve out of non-performing entities then come to play, and then you find yourself in a restructuring position. There are two other very key things that people do not really pay attention to. Sometimes you have business strategies, but your structure as an organization is not really aligned to your strategy as a business. Also, when you look at the performance evaluation process of a business, and a lot of times the way you evaluate your managers or your business executives actually could be motivating or demotivating to achieving your organization's goals. So when you, as an executive or a restructuring practitioner, when you do ask yourself a lot of these questions and you're getting negative indications, then it means that you probably should be considering one level of restructuring or the other, either from an operational standpoint or from a financial standpoint. What are the key triggers that would necessitate a restructuring or a rescue plan? And this is bringing the goals home and really talking about a stress situation or a stressed business. One is, if you find yourself in a situation where you're continuously extending your credit, then there's a question around the going concern of that business. Another situation is where there's an impending breach of a debt covenant, and you probably need to get into some debt restructuring conversations with your lenders and your financiers. I talked earlier on about your market positioning and also issues around insolvency, which have been earlier mentioned, going concern challenges in most cases. In some cases, might not even be related to internal issues, but could be regulatory driven. We would, for those of us in Nigeria, we would remember the issues of the banking consolidation and industry recapitalization and things like that. Those would typically necessitate some form of restructuring or the other. Again, as earlier mentioned, unprofitable profit lines or service lines. When you find yourself in a stressed position as a business or as an advisor looking at a business, and practically, what exactly are those things that you should be doing in order to set up a restructuring or a rescue plan for that business? I've highlighted 3 key steps, and this is vital and from experience, usually very key. First things first is to ensure or get to a position that you can guarantee the survival of the business that you're looking at. And this is focused on a business that is stressed or almost getting to the point of distress, and you're seeking to avoid an administration, an insolvency or bankruptcy situation. In ensuring survival, one of the key things that needs to be done is really understanding what exactly are the key drivers of the crisis situations, and that would necessitate a current state assessment of the business itself. Having understood what the key drivers are, you then want to have a short-term cash flow management cash flow projection. Typically, when we do this, it's usually about 3 months, 13 weeks projection. And what you want to do with this is look at the cash flow of the business differently, and begin to get a bit more closer to a daily monitoring of cash flow and daily monitoring of cash flow, and have a proper angle of your working capital management. What this does is allows you to understand the crucial activities that either take cash away from the business or bring cash into the business. Having understood that, you then begin to look for ways to extend your payment terms. Really, in situations like this, you want to focus on payment terms that are non-core to the operations or to the revenue generating capacity of the business. So non-core activities, for instance, that you can either delay payment for, and here is not focusing on your key suppliers and what have you. After that, you also want to look at your costs and ensure that if there are cost reduction opportunities, you want to actually take advantage of those opportunities and reduce cost. I've highlighted areas around discounts and rebates. From experience, especially when we look at companies in the manufacturing space, you do find that companies will want to give cash discounts and give rebates for products. But when you do an historical analysis of the impact of those discounts and rebates, you realize that the benefit the company or the entity in itself obtains from it does not actually compare to the cost of the discounts being awarded. If you do find a company in that situation, a good way to actually save costs is let go of those discounts, because the impact on the business in itself would be positive rather than negative. Having gotten an angle of your cash flow, at least over a 3 months period or a 13 weeks period, it will clearly show to you where you have gaps and where you would have shortfall within that period. And what that then helps you to do as a restructuring practitioner or as an executive looking to manage a crisis situation is prepare to have negotiations where you can actually bridge those shortfall liquidity needs, either having conversations with your suppliers ahead of time or going into very honest conversations with your lenders, your bankers, and even your investors, as the case may be. The reason why this is important, or why this step is important, is if you want to then have any conversations with either one of your stakeholders, having a clear analysis of what the gap is shows that you have an understanding of what the issues are. You have a plan around it. You know how you want them to help you, and it helps you sell your turnaround story better. And it's usually clearer when you can put that in front of them and have a conversation around what exactly is in it for both yourselves and also them, and also your stakeholders. Having done that, right, now you want to get a clear, you want to put a clear plan in place, and developing a roadmap to turn things around would involve actually putting together different options. What we do find in most cases, restructuring cases or turnaround cases, is that one option never actually solves the issue. So for instance, you might have a situation where a business is highly geared and the cash flows of the business is really not adequate to meet principal and interest payments in the near or foreseeable future. One of the key steps would be either disposal of non-core assets, but the question is that enough to solve that issue? And also either solve the issue of your leverage and also provide additional working capital for the business. A scenario that you could look at in such a situation is leveraging the disposal of non-core assets and also injecting additional equity into the business, either through existing shareholders or pulling in additional shareholders. But again, there are considerations to then look at depending on the specific situation of the business and expectations of your existing shareholders. Having done that, right, is then how do you begin to realize the goals or the plans that you put in front of you? This is where management really needs to then begin to be honest with itself. Managing a business on a going concern basis, it's usually and completely different from managing a business in a crisis situation. So you want to ask yourself, is management really equipped to manage the situation? You're not only communicating on a daily basis with internal stakeholders, there is active communications with external stakeholders and ensuring that they're properly managed. If you do find out that there is a need or there's a gap within your management capacity, it's a good time to actually bring in external help. And most cases, this is where you then bring in a chief restructuring officer who has experience managing similar crisis situation, particularly sector related experiences. Having done that, you then want to implement your plan. And as you begin to turn around the business, what should be focused is how do you ensure that you don't find yourself in this situation in the near future. And this is when it is a good idea to do what we call an independent or an integrated business review of your strategies and your business, so that post the crisis, you can actually position yourself for growth going forward. A lot of things have been said in the previous slide, and the issue is it's always good to put a plan on the table, but it's usually difficult to execute it. If I would summarize this slide, I would say there are three key things that you need to have at the back of your mind, and you need to ensure that you get an angle of as you go into a restructuring process or a rescue process. What exactly are those three things? One is a key understanding of your business. The second thing is understanding who your key stakeholders are and what exactly are the priorities for them. Those two things help you then manage the last one: effective communication and management of your key stakeholders. Key questions you need to ask yourself around understanding understanding your business. One, is the business actually resilient enough to survive the crisis, or there are certain times that you've suddenly found yourself in? The second would be, how effective is your cash flow planning? And is that integrated into your entire business? I would pause and give an example here, because it could sound, just giving an example, when you look at a typical manufacturing business or even a distribution business, you find out that the finance team is really focused on cash flow, working capital management. And the sales force is focused on something else, selling. The procurement team is also focused on ensuring that there is no stock out. And all these three key teams are working independent of each other. Most times when we get into a business and we do look at their strategies across different departments and functions, you find out that everyone is working at cross purposes. What you need to do as an organization is to ensure that everyone from your sales force to your production team to your procurement team and even the finance team are working in ensuring that they optimize cash flows within the business and ensure that we have one goal. Also, there's also you understanding what exactly is the cause of or the driver of the crisis situation that you found yourself. Some of the challenges that you might face would include things like, how do we implement or manage a forecast over a 13-week period on a day-to-day basis? We do find out that finance executives, CFOs are not, they have a budget in place, they have a plan in place, but they're not used to that active level of managing financial forecast in a crisis situation. So this is something that requires keen consideration. Also, there are issues around the time lag between getting consensus between institutional investors and lenders. Also, issues around promoters wanting to retain control, limiting what kind of levers you can pull to save the company. Also, how do you monitor, evaluate your restructuring plan vis-a-vis regulatory and tax issues, and actively managing every stakeholder, including your board, your management team, and even employees. The last slide I have here, what I've tried to do is highlight certain levers that you could pull quickly in a restructuring process. One of it is actually right sizing and delayering. And what exactly does that mean? Right sizing is ensuring that when you have excess resource capacity, you probably want to you want to quickly understand what resources excess and how do we rationalize that. Delayering is actually pretty much reducing your levels of management in such a way that operations are a bit smoother and you can even save some cost in doing it. One of the key things you need to then consider and manage effectively is reputational issues around rationalizing, staff rationalization and things like that. Another lever that can be pulled is actually outsourcing some of your operational functions within the organization. By outsourcing it, you save some cost, and also you probably get advantage of advantages from the outsourced vendor that you've used, where they can do things a bit better. But there are issues around loss of quality, managing information, especially if you're operating in an industry where patent and brands and things like that are protected, and you don't want to share that. Something else that can't be done is, I probably have mentioned this earlier, is a sale or lease back scenario where you can easily inject liquidity into the business and you're leasing out, you're selling core assets of the business, but leasing it back, and your operations are not, in a sense, impacted. Another one is actually disposal of non-core assets to bring in liquidity. And this would help sustain the business in the short term as you then prepare yourself for longer term strategies to really turn around the situation of the business. I think at this point, I would like to say a big thank you for listening to me, and hopefully I'll take some questions when the time does come. Thank you.
Thank you very much, Tosin. We're now almost 3/4 gone into our session, which began with the first two speakers looking at the legal framework for both formal and informal restructuring and rescues. And these next two speakers looking at the practical and the accounting aspects of the accounting issues that arise in restructuring. So we've had Tosin. Thank you very much, Tosin, for highlighting those practical issues that one has to bear in mind in planning successful restructuring. We're now going into our final speaker for this session. But before we do that, I'd like to remind all of us that anyone who has any question should put it in the chat box so that after Mr. Nsofo's presentation, we could take the questions rather than having to stop for a while for people to ask their questions. So anyone who has any questions should please put the question in the chat box. And for those of you who are here physically, if you could write your questions down and hand them over either to the coordinator or to myself, I'll make sure that those questions get put to our presenters at the end of the presentations. It gives me great pleasure to call on Amechi Nsofo, who, as you can see from his profile on page 22 and 23 of our program, is a partner in Grant Thornton, UK, and is the head of the Africa-based practice of that firm in the UK. Amechi, the floor is yours.
Thank you very much, Fidelis. And everybody, it's a pleasure to be here with you today. I'm actually joining from London. Unfortunately, due to COVID, I cannot be with you in person. I am going to focus my talk. I don't want to spend too long on it. I want to spend 10, 15 minutes so I can leave enough time for questions. And given that I am bravely the only thing that's standing between you and lunch, I think I need to be very disciplined with my timing. So I'm going to be speaking about restructuring plans. Can you share my slides, please? So I'm going to be speaking about restructuring plans and the valuation aspects of restructuring plans, and then I will be talking a bit about why this is relevant to the Nigerian market and why this is relevant to Nigerian companies. So if you go into the next slide, please. So this is actually my killer slide that I use on absolutely every presentation that I do on insolvency. For an effective insolvency framework, you need to be able to deal with businesses through all stages of decline. Not only when you get into the red box in the right-hand corner, which is insolvency, but also when the business is declining and pre-insolvency. And that's why it's important that in Nigeria, we look to further develop our non-insolvency frameworks. And I think it's, using the things that Jide mentioned earlier, informal restructuring arrangements and also formal restructuring plans, which I'm going to come on to as part of my talk. Next slide, please. So what is the Restructuring Plan 2020? It is a new mechanism in the UK. I think most of the people on this call will know what Companies Act scheme of arrangements are. This is a turbocharged scheme of arrangements. It is a super scheme. Sorry, can you share the slides with the audience? Someone just said they can't see it. It is a super scheme of arrangements, and there are many differences between a restructuring plan and what a scheme of arrangements will do for you. In terms of the differences, the restructuring plan is can be used when companies are encountering difficulties, financial difficulties, and it needs to be the case that the restructuring plan, which is submitted to the courts, can actually address those financial difficulties that the company is encountering. When you look at the voting mechanics of a restructuring plan, there's no numerosity test. So the number of parties voting to put through the scheme or to put through the restructuring plan doesn't need to be above 50%, which it needs to be in the case of the CVA. And then finally, dissenting creditors. So creditors who don't agree with the restructuring plan can be dragged along by those creditors that consent to the restructuring plan. And that's called a cross-class cram down. So I'm going to use this presentation to kind of go through practically what that element of cross-class cram down looks like and what you need to have in place to be able to drag your dissenting creditors along with you when you're trying to get a restructuring plan voted through. Before I do that, I just wanted to mention why this is relevant for Nigerian companies. It is very relevant because under the Restructuring Plan Act, or rather the Companies Act, paragraph 26A, you only need to have a sufficient connection to the United Kingdom to be able to submit yourself for restructuring plan through the English courts. Now that differs from an administration, a CVA, and any other form of insolvency, because under those formal insolvency proceedings, you actually need to have a center of main interest over here in the UK. So the test to be able to access the English courts under a restructuring plan is a lot less severe than it would be under the other plans that exist. For example, administrations and liquidations and CVAs. Next slide, please. So valuation is very important when it comes to restructuring plans, because whoever has an economic interest in that restructuring plan and in the company going forward usually has a say as to what happens when it goes to courts. So I'm just going to use the capital stack on the right, on the left-hand side, to demonstrate a live case that we're currently working on at the moment. So as you can see from the capital stack, senior debtors comes to around $47 million. And then there's $18 million of junior debt or preferred equity. And then equity in the business is $22 million. And then profits, if you like, out of the money equity is about $10 million. So the security interest of the debtors, of the creditors, sorry, at the bottom of that capital stack, they have more rights and they can, if you like, vote through a restructuring plan against the wishes of the dissenting creditors. So the way that happens in practice, if you look at the right-hand side, is that we go to the courts and we present what we call a plan A, and we say to the courts, this is the plan that we need to vote through to alleviate the financial difficulties the company is going through. Now, if under our plan A, there's a valuation of $50 million, it shows that the senior lenders or the senior debts in this case will get fully paid out, and there will be $3 million of a surplus left to pay some of the junior lenders, who then gets a 17% return. Now, to make this a compelling case for the judge, we then say to the judge, well, the relevant alternative, if you do not vote this plan through, is the plan B, which will result in an outcome for the stakeholders that will generate cash of $10 million. Now, $10 million, as you can see, is far significantly less than the senior debt. It only results in a senior debt, senior lender return of 21%, but the junior lender gets no return. Now, under the restructuring plan, we can drag that junior lender along with us and get them to effectively vote against their wishes for plan A for two reasons. And there's two reasons why we can do that. Number one, under the plan A, the junior lender has a better return than it does under the plan B. So you can see under the plan A, junior lender 17%, under plan B, 0. And then the second reason we can do that, so the second criteria, is the fact that the senior lender has an economic interest in plan B. So the senior lender, as you can see, gets 21% return in the plan B scenario. And if those two criteria get met, then the judge will vote through the restructuring plan against the wishes of the junior lender. Next slide, please. So, that's kind of a practical summary of what we go through when we vote restructuring plans through the courts. Now, our work as accountants lies in valuations and in valuing what the plan A outcome looks like, and also spending some time doing what's called a comparator reports, and that's the plan B scenario, where you say under the relevant alternative, the creditors are going to be in a worse position than they would be under the restructuring plan. So you need to be supported by experts in this area, both valuation experts, insolvency practitioners, tax experts, and also lawyers. And then I've already spoken about the importance of the relevant alternative, but doing that comparison between the Plan A and Plan B for the restructuring plan, you need to have a significant gap. We call it the clear water requirements. There needs to be a gap in outcomes between what the creditors get under the restructuring plan versus what they stand to get under the plan B. And then you also have to be mindful of the fact that if you need to drag your junior creditors along under a cross-class cram down, there's certain criteria that you need to be able to meet. And I went through that criteria earlier when I spoke on the last slide, looking at those at that example that we're currently working on. So it's very important for the UK insolvency markets to, I guess, further develop the rescue pathway that's in place to actually rescue businesses, so that when businesses are going through financial difficulty, the only option on the table is not a liquidation. So I don't know if that's my prompt, but I think I will stop now and maybe hand over to the chair to take any questions that exist on both my presentation and that of my fellow panelists. Thank you.
Thank you very much, Amechi, for a very clear and incisive presentation. So that brings us to the end of the 4 presentations. As I mentioned earlier, the first 2 addressed the legal framework for restructuring, and the last 2 looked at the practical aspects of restructuring, including in particular valuation. We're now in the question and answer session, and I'll take the privilege of the chair to ask my own question, or maybe my own comment first. As I understand it, the informal rescue procedures, we would have had quite a few, because generally an informal rescue procedure is basically an agreement between creditor and debtor. The terms of such an agreement would normally be limited by the imagination of the parties. Anything can be agreed. So unlike a statutory procedure where you have constraints imposed by statute, both in terms of procedure, in terms of timelines and so on, in relation to informal procedures, there are no such statutory constraints. But informal procedures don't exist entirely in a vacuum. I believe that, as Jide mentioned in his presentation, the debt equity swap is an example of an informal rescue procedure. So if a company is indebted to you and agrees to take equity instead of insisting on being paid the debt, that becomes an informal rescue. So also the scheme of arrangement, which I believe in Nigeria we're more familiar with. In many jurisdictions, the scheme of arrangement is a paradigm informal rescue procedure. And as Amechi mentioned in his presentation, Part 26 of the UK Companies Act 2006, which was introduced by the Corporate Insolvency and Governance Act of 2020, introduced what he called the turbocharge scheme, which allows cross-class cram downs. But that also is an informal rescue scheme. So why can't we use the scheme of arrangement in Nigeria, not just the London approach, but the scheme of arrangement in Nigeria as an informal rescue procedure? We understand the scheme of arrangement very well here because in 2005 especially, virtually all the banks that consolidated used the scheme of arrangement. So we do have knowledge and experience of schemes being used in the mergers and acquisitions sphere. Why can't we extrapolate from that, given that it's the same statutory framework, into rescues. What is perhaps significant is that the UK is very attractive to many companies as a prime center for restructuring, precisely because of the UK scheme of arrangement. So why can't we use our own scheme of arrangement to achieve similar objectives? I made sure also mention the fact that unlike the statutory procedures of administration and CVA under the UK, where you need to show that England is the center of the main interest of the company, COMI, in relation to both the turbocharged and the non-turbocharged scheme of arrangement, all you need to show is that there is some connection with the UK, which also you can demonstrate in very many ways, usually by showing that there are creditors in the UK, and that will be enough to give the UK court power to assume. And it's not dissimilar from what we see in relation to winding up foreign companies, even in Nigeria. In order to assume jurisdiction over a foreign company to wind it up, you have to show that it has some connection with Nigeria. And so you have all or most of the ingredients required to make informal rescue procedures effective in Nigeria. Also, you could use the provisional liquidation as an informal rescue procedure, and I'll come back to that. I've mentioned the debt equities of the provisional liquidation, the scheme of arrangement. But of course, as is often said, the informal rescue schemes have various constraints. For example, there is no moratorium, which means creditors are free to present winding up petitions. Others are free to take enforcement steps in the courts. And in that way, you might just end up balkanizing the debtor before you've put together a successful informal rescue scheme. One solution to that, of course, and which the UK courts have also used, is for the courts themselves to exercise inherent power to stay proceedings or to stay winding up proceedings. So although the statute does not create a statutory moratorium, in practice, the courts can achieve the same objective by exercising the power to stay winding up proceedings or to stay general legal proceedings pending the expiration of a certain minimum time. Other constraints to maybe the use of informal rescues in Nigeria might include, for example, the fact that it is said that in Nigeria, you cannot have a provisional liquidation unless the winding up petition has been advertised. The whole point of rescuing a company through a provisional liquidation is to save its business. But if you've already advertised it and announced to the whole world that the company is burst, what's there to rescue? But I understand that there is a first instance unreported decision by a judge whose name I shall not mention, just to save him the embarrassment, that says you cannot appoint a provisional liquidator unless the petition is advertised. I believe that decision is wrong and is based on the misreading of the winding up rule, the company winding up rules. There's certainly no such requirement that you must advertise a winding up petition before you can appoint a provisional liquidator. On the contrary, provisional liquidators are appointed at a very early stage, often to protect the assets of a company and to provide and to prevent them from dissipation. But once you've advertised the petition, the crooks know you're after them, and then the assets will go walkabout. So not only is that decision wrong as a matter of law, it also does not make much common sense. So, but we need to address that, because often I know how we use precedent in Nigeria. Someone is going to tell you that it has been decided, but that decision is wrong. So we shouldn't regard that as a constraint to using the provisional liquidation as an informal rescue provision. I'll come to how Kama has tried to address it, but I'd like to mention just one point that Amechi mentioned, which is the point of valuation. Because in the UK, in relation to schemes of arrangement, and the reason why they have been so successful is that creditors who have no interest are not allowed to vote. They're not allowed to obstruct the procedure, which is why valuation is key. If, for example, a company owes 20 billion naira and has assets of only 1 billion, and you have senior creditors, I say secured creditors, who are owed 10 billion, it's clear that no one else has any financial interest. I mean, they may be creditors, they've got their paper claims, but in substance and in reality, they have no interest in the restructuring. They have no skin in the game. That proposition was established a long time ago, around 1913, in a case called RET Company. That persons who have no interest in a scheme should not be invited. They have no entitlement. And therefore, you don't need to get their views and you don't need to allow them to vote. And that principle has been applied in the UK, even in the context of statutory schemes like CVAs and administrations. So, for example, you see a case like Maxwell Communications Corporation, MCC, where the court said, of course, a creditor who has no financial interest in the scheme does not need to be. But I can imagine that in Nigeria, where we thrive on procedure and the abuse of procedure, the use and misuse of procedure, someone who has absolutely no interest will go to court and say, I'm a creditor, my consent has not been sought, my views have not been sought. And then some very gullible judge who does not understand the principle of a T company, the MCC and co, will say yes, but the statute says creditor. It doesn't qualify it with interest. And that shows you that you need to understand how these things might be used to some advantage. And finally, on the question, maybe not finally, I have two more points to make. One of the constraints in using informal rescues in Nigeria, especially the debt equity swap, is that for some institutions, the statute prevents them from holding equity in non-bank financial institutions. So you say you have scored an own goal. You want to promote informal rescue procedure, but then you ask the banks and the insurance companies, which are the principal creditors in any restructuring, that they cannot take equity in non-bank companies. So you're already defeating. It means that there must have to be a payout by someone instead of doing the simple debt equity swap. In addition to that, as I mentioned earlier, there is a question of moratorium. But there is a curious new solution that I think the newcomer tries to impose in relation to informal rescue procedure. And that solution you find in section 717 of CAMA. And I'm sure many people who have looked at it will be wondering what on earth is going on. What is it trying to do? But it says, section 717 says, no winding up petition or enforcement action by a creditor, secured or unsecured, shall be entertained against any company or its assets that has commenced a process of arrangement and compromise with its creditors for 6 months from the time that the company, by way of affidavit, provides the following documents to court. A document setting out the terms intended to be proposed to the creditors in an arrangement or compromise. B, a statement of a company's affairs containing the particulars of a company's creditors and its debts and other liabilities and of its assets. And C, such other information as the court may require, and a statement that the company desires a protection from a winding up process pending the completion of the arrangement or compromise. So, of course, you have to ask yourself, what exactly does this curious provision mean? Because we've always said that one of the weaknesses of a scheme of arrangement is the absence of a moratorium. But for the first time, you find an attempt to impose a moratorium on the presentation of winding up petition and the enforcement of creditor remedies set out in section 717 of the new CAMA, albeit there are conditions. So this one might become our own turbocharged rescue procedure, because first we're familiar with schemes of arrangement. And one of the weaknesses we say exists in relation to statutory schemes of arrangement in England and everywhere is the absence of a moratorium. But we have now tried to address the absence of a moratorium via Section 717. And it remains to be seen how the court interprets Section 717. But on the face of it, I don't see why it has not been pressed into action, because unlike Chapter 17 and 18, the CVA and the administration, which are still in limbo pending the making of the insolvency regulations, we can use statutory schemes coupled with Section 717 immediately. And it addresses the main weakness of informal rescue procedure, i.e. the absence of a moratorium, because it gives you a 6-month moratorium, and I'm sure that that period can be extended. Of course, you know that in a scheme, there's already power to cram down on the dissenting minorities once you get the statutory majority. So those were the initial comments I wanted to make, using and abusing my position as chair. Now, may I invite other comments in relation to any of the 4 topics that we listened to this morning?
Okay. Thank you. Thank you, sir. So now we have the first question. This is coming from one of the participants online. And the question is, how is the IP remunerated in rescue and restructuring engagements?
We have our next session is on insolvency practitioners, and I would ask that questioner to keep the gunpowder dry and to wait for the next session where those issues will be addressed in detail.
So we have a second question here, and this one is directed to Tina Lockwood. And the question says, in pre-packs, who makes the decision to engage in pre-packs, directors/IP? As this decision to pre-pack may actually lead to asset stripping. So if we can have Tina respond.
Yeah, hello, hope you can hear me. It's a very good question, and I think it goes to the heart of the mischief that the English government has tried to legislate and protect against. So ultimately, the decision to proceed with the pre-pack is on the administrator. So the administrator will be the one that is contracting to sell the business and the assets and leave certain creditors behind. So it will be as part of the process around agreeing with the company what that pre-pack will look like, and dealing with the evaluator to bring on board their independent thoughts around that process that is thought to now bring a bit more transparency and accountability to that process. But the very short answer is that it is on the administrator to effect that transaction.
All right, I'm sure that answers the question. So this question is to Mr. Ogundikbe, if we could have him back online. And the question says, who decides the lead creditor in informal rescue procedure? And what are the parameters in deciding who the lead creditor would be?
Okay. In an informal situation, one would expect that the lead creditor is likely to be the creditor that's owed the most. And in the sort of situations that one envisages, if you have an intermediary, the intermediary will be looking to the most powerful player, the one who can influence the proceedings the best. So essentially, I believe that the decision would be by the creditors themselves, looking amongst themselves and selecting whoever they feel is likely to best represent their position. And this usually will be the one with the most at stake. I hope that has answered the question.
Thank you. Thank you, Mr. Ogundikbe. So we have another question here, and this one is to Mr. Oluwatosin, and it goes thus. It says, in your presentation, you noted that there are many options to giving direction in the restructuring process. What do you think should be the main consideration that the COI or reliever should consider taking a company's capital structure and financing structure into consideration? So I'll take it again. In your presentation, you noted that there are many options to giving direction in the restructuring process. What do you think should be the main consideration that the COI or the receiver should consider taking a company's capital structure and financing structure into consideration?
Okay. At the point, just to answer that, at the point where you already have a receiver in the business, then you're really not the control is out of the shareholders. So what the receiver is trying to do is get as much cash into that business. When you put your capital structure at the center of the conversation, what really you're trying to do is to ensure that you manage your your lenders appropriately. So again, your major stakeholder then becomes your institutional financiers and your lenders. And your goal as the receiver is to ensure that if you need to ensure survival of that business, you want to work directly with them and ensure that they can continue to support the business, or you then probably bring in an external investor into that business with the agreement of existing investors to reliever the capital structure of the business.
Thank you. Mr. Mechi, we have one for you, and the question is, on the issue of informal rescue procedures, would it be out of place to still have put down in unity certain agreed resolutions in the restructuring process, notwithstanding that this is done outside the statutory obligations?
Can you repeat the question?
Okay. On the issue of informal rescue procedures, would it be out of place to still have put down in unity certain agreed resolutions in the restructuring process, notwithstanding that this is done outside the statutory obligations?
Yeah, I think that actually goes to the core of what an informal restructuring process is all about. It's about I don't want to use the word circumventing, but it's about navigating around the statutory guidelines and the statutory restraints that creditors, debtors, and security holders might have in place. And the reason that it is it is beneficial to go down that route is that usually going down the formal route tends to be more value destructive and expensive for everybody concerned. So the answer is that it would not be unreasonable at all, and I would expect that to be the case in restructuring plans and informal restructurings. That happens. Thank you.
Thank you, Amechi. Are there any questions from the floor? Does anyone have any question in relation to any of the presentations?
We have a question here.
Good afternoon, everyone. My name is Fuluke Akimoladu. I actually asked the question to Mr. Tosin. I think I need to make a bit of a clarification. The question was, okay, if I understand the fact that when we get to the point of receivers, we're no longer really talking about restructuring within the company. But when the company has an option of restructuring and is looking at its capital structure, what are the first things it has to look at if it's having to make the decision of either making use of their existing investors or having to bring in external investors? What are the key points that the company needs to look out for?
Tosin, hopefully that has clarified the question. Can you throw any further light?
Recording in progress.
While we wait for Tosin to come back to rejoin and answer her question, does anyone have any other question? Or comment?
Questions, comments, or contributions? Okay, I see a hand over here. Thank you.
Okay, my name is Ebele Chukweneda from Punuka. I had asked the question to Mr. Ogundipe on who decides the lead creditor and what are the parameters. Why I actually asked that question is that the lead creditor may not actually be the person that is owed the most. May be the person that has a secured debt. There may be other things around it that may decide who the lead creditors are. And that is why I asked who makes that decision and what are the parameters. Are there other things that you can look into? And if that decision has been made, does it mean that the other creditors cannot challenge that decision? I don't know whether he can still throw more light on that.
Thank you.
Well, I acknowledge that the party that's owed the most is not necessarily the one who should be the lead creditor. But you have to understand that in the informal proceedings that I discussed, there are two things. First, there's an intermediary who sits there and brings the parties together. Then there are creditors brought together who discuss amongst themselves. So essentially, the real thing is that a decision is made amongst the relevant parties, the creditors, the debtor company, which really doesn't have that much to say, and the intermediary. I don't think that it would be right to lay down any specific rules or say that this is the way these things have to be done. The major thing is that the focus has to be on parties getting together, agreeing to hold off so that they can discuss and endeavor to find some means by which the business can be rescued and can be maintained as a going concern. I think that those are the primary factors that need to be considered. And it's difficult to lay down any specific or hard and fast rules as to how this should be done. What needs to be emphasized and kept in mind at all times is that there's a process through which the parties will agree on trying to achieve a specific outcome. So whichever party they feel would be best positioned to lead that effort should be the one that is selected.
Thank you, Judy. Neda, does that answer your question? And I think it must be right that if it's an informal process, by definition, there is no statutory protection of a leader's tenure. And if other lenders have lost confidence in the lead creditor, there's no reason why the lead creditor cannot be removed. But of course, it's often the case that you might have a very troublesome minority creditor who does not want the lead creditor. Not because the lead creditor has done anything objectively wrong, but because this creditor doesn't want it. And in such situations, it will usually be the majority. As long as the lead creditor enjoys the confidence of the majority, is likely to remain. But in Nigeria, we know that the minority creditor might rush to court quickly. But I think we need to reorientate them and to re-educate both the practitioners and the users of insolvency services as to how these procedures are intended to operate. They're not intended to give one small creditor a veto right or power over the entire process. That's not the spirit. And it's to understand that, as the title suggests, arrangement and compromise. It's a bit of give and take. You give and you take something. Everyone often takes a haircut. And the question is often, where does the value break? And how much haircut do you need or can you survive with? Right.
We have a question here.
Yes.
Good morning and thank you. My name is Okori Carlo. I have a question for Mrs. Lockwood. Thank you, Tina. I just want to have you give us a bit of insight. In Nigeria here, as has been mentioned, there is a lot of practice in terms of receivership. And I do know that you've had administration and CVAs well entrenched in your system. I would like for you to, enlighten our audience on the interact between receivership and these business rescue procedures in the UK and the impact of, triggering any of these, because it's important for many of us here. The practitioners have been under an old regime. It may be very important for them to have a good perspective on that. Thank you.
Yes. Can you hear me? Hello. No, it's a good question, and actually, receivership is a very well entrenched process within our law here as well, and it isn't an ignored process. It still has a very relevant place, and it has a very relevant place in respect of the ability for a secured creditor to be able to take steps to enforce his security rights in relation to a particular asset. And I think, as I mentioned, the difference there is that the receiver will act and will owe his duties to that creditor, to that single creditor, and he will take the steps that are necessary to realize that asset, to repay that creditor. Whereas the other processes are more collective. They are for the interests of creditors as a whole, essentially. But it does still have a very relevant role to play. And actually, we still use receivership quite commonly in respect of property and actually taking control of property assets. And that could be real estate assets where you appoint a receiver to take back that property, to sell it, to repay the secured creditor. There are deficiencies, however, so the receiver doesn't have the same breadth of powers as you might see an administrator have. So a receiver can't pursue other pockets of recovery through conducting investigations, etc. I hope that helps to answer your question.
Thank you, Tina. Is there any other question? I don't see any other questions here. Well, in the absence of any further questions or comments, all that is left for me is to thank our speakers and presenters for their very excellent presentation today, and also to thank our audience, both those present physically and those who have joined us virtually, for your patience and for your interaction. Thank you and have a good afternoon. Lunch is now served.
Thank you.
Thank you, sir. Please put your hands together for our President. Thank you so much, sir. We'll be going on a short break, but I'd like to let us know that we have the bathrooms, the restrooms within the hall towards my right. The two doors there, the male and the female. So in case you need to use the restrooms, you find them within the hall. Before we go for lunch, we'd like to appreciate everyone here today, even those who have joined us online. We have our online packed with over 99 people, and it is indeed a pleasure to have every one of you here. Thank you so much for bringing out time from your very busy schedules to be here. We want to recognize every single one of you and let you know that without you, this event will definitely not be a success. But we would also like to recognize the presence of certain people, personalities with us here today, both within the hall and online. So, but when we come back from the break, we'll get to do that. But in the meantime, we'll take 30 minutes and we'll go on a short break. We'll be having lunch, and I believe the ushers will get to serve that, and it'll be passed around. Thank you.
Thank you.